59th anniversary of Bloody Sunday in Selma, Alabama. On that infamous day in 1965, 600 Americans, led by young John Lewis and Reverend Hosea Williams, were met by police wielding billy clubs, bullwhips, and tear gas as they marched across the Edmund Pettus Bridge to protest the disenfranchisement of Black Americans. Just months later, Congress finally passed legislation to protect every American's right to vote. The Voting Rights Act, or VRA, passed with 77 votes in the Senate, an overwhelming bipartisan majority. When the VRA was last authorized in 2006, not one senator, Democratic or Republican, voted against the bill. Next year will mark 60 years since the Bloody Sunday and the passage of the Voting Rights Act. But as a result of a series of misguided Supreme Court decisions, there's been a significant deterioration of the fundamental right to vote in America. In 2013, 5 Republicans appointed justices on the Supreme Court dismantled a key feature of the Voting Rights Act by throwing out the formula for jurisdictions subject to preclearance. Preclearance had required states and localities with a history of voting discrimination to submit any changes to voting laws and procedures to the Justice Department or a federal judicial panel for review. Congress repeatedly reauthorized that formula with bipartisan support, overwhelming bipartisan support, in light of reams of evidence demonstrating its continued value. In the days following Shelby County versus Holder, Republican-led states immediately moved to enact discriminatory voter suppression efforts. Voters now wait years for court decisions when they challenge these laws and have to endure elections with these restrictions in place even when they're later found to be violating federal law. In 2021, the court's right-wing majority continued its assault on the Voting Rights Act with its decision in Brnovich versus DNC, creating judge-made, more difficult standards for plaintiffs in voting rights lawsuits. Many Americans fear that this attack on voting rights is part of a coordinated assault on our fundamental rights and institutions, as government officials, including a former president of the United States, try to overturn an election and sow doubt about its integrity. We can restore confidence in our democracy by ensuring that every eligible American can vote without fear of disenfranchisement. Congress can do that just by passing the John R. Lewis Voting Rights Advancement Act, which would restore the VRA. Some have suggested we don't need this law, pointing to record-breaking voter turnout in the 2020 election. But take a close look, and if you do, you'll see the racial turnout gap is actually growing in this country, fueled by these voter suppression efforts. In 2012, the year before Shelby County, the turnout rate for Black voters was higher than the rate for white voters in 7 of the 8 southern states subject to Section 5 of the VRA. 8 years later, after the end of preclearance, the turnout gap has returned. Black voter turnout has fallen dramatically compared to white voter turnout in these states. Since the Shelby County decision, states have passed 94 restrictive voting laws, including discriminatory laws that the Department of Justice had previously rejected under preclearance review. This includes laws that limit the use of mail ballot drop boxes, impose strict ID requirements, cut hours for early voting, and purge voters from registration rolls based on inaccurate databases. Voters in 27 states will face new restrictions on their right to vote in the presidential election. And without the full force of the Voting Rights Act, their rights are at risk during one of the most critical elections of our lifetime. We must pass the John R. Lewis Voting Rights Act, Advancement Act, to protect what he called, quote, the most powerful, nonviolent tool or instrument we have in a democratic society. Senator Graham is unable to be here at this moment because he's attending the judicial conference across the street. Oh, on cue, he arrives. So let me recognize Senator Graham.
Thank you, Mr. Chairman. I was over at the judicial conference speaking to our judges. So the committee is taking on reforming the way we vote. A lot of people on our side think the voting system needs to be looked at when it comes into mail-in ballots. There are accusations being made that people can't vote in states that have voter IDs fairly. I don't believe that for 1 minute. This bill is an effort, I think, to rewrite federal law in a fashion that would make it harder for states to implement voter verification. That we're trying to solve a problem that I think doesn't exist. I think most Americans participated at the highest level in history in the last election. We had more people vote than any time ever, anywhere. And you're right about voting. It is a cherished right that needs to be protected, but I don't see this as an effort to protect voting as much as it is to create a situation where states cannot, in a reasonable way, validate who's voting. The only thing worse than being denied voting, or at least equal to it, is somebody not eligible voting. And a lot of concerns about that. So just think about how many times you have to show an ID to do anything in America of consequence. So my state and other states have passed voter ID laws. They're designed to make sure the integrity of the ballot box, not to disenfranchise anybody. In South Carolina, we had record participation in the last presidential election. 2022 was robust. So you won't find much support for the John Lewis Voting Rights Act on this side of the aisle. A lot of admiration for John Lewis. He took a beating for making America better. So we admire the name John Lewis and his heroic efforts during the 60s to make America a better place. But I think virtually all of us, if not all of us, will see this as an attempt to rewrite Supreme Court decisions that were long overdue. My state has been under scrutiny for a very long time. And I am proud of the way we vote in South Carolina. We've come a very, very long way. And I think the results of our system and other states that have been under scrutiny have borne fruit, and the Supreme Court recognized that. This is something the left doesn't like, but it's real. People can vote in America fairly, and the idea of changing the Supreme Court decision is not about expanding voting. It's about curtailing efforts at the states to protect the ballot box. We will be against that.
Before we turn to our witnesses, let me lay out the mechanics for today's hearing. Begin with a member panel. Each member has 5 minutes and an opening statement. Then switch to our second panel. Once again, 5-minute opening statements from each witness and a round of 5-minute questions from each senator. First, we begin with a statement from Senator Warnock, our colleague from Georgia, who has been an exceptional partner in introducing this legislation and has firsthand knowledge of voting laws at a state level and the impact they have on the actual election. Senator Warnock, you may proceed.
Thank you so very much, Chair Durbin and Ranking Member Graham, for inviting me here today. Across the country, the right to vote is under assault, and we must urgently pass voting rights legislation. I had the honor of serving as John Lewis's pastor. I presided over his funeral. But while I was his pastor, I'm very clear that he was the mentor. And 2 weeks ago, I was deeply honored to introduce with Chair Durbin the John Lewis Voting Rights Advancement Act, legislation named in his honor to protect the right to vote for all Americans. As the first black senator from Georgia, let me be very clear today. I would not be here without the Voting Rights Act of 1965 and its protections that enabled millions of Americans to have their voices heard in our democracy. But a series of Supreme Court decisions have gutted pre-clearance a very important and powerful tool, and other provisions of the Voting Rights Act enabling state lawmakers to roll back voting rights across our country. I have seen the results firsthand in my state of Georgia. I don't need anybody to tell me about it. I've seen it, I've experienced it. After the 2020 elections, partisan actors in the state legislature passed a sweeping voter registration law, SB 202, that made voting harder for thousands of Georgians. And let me offer just a few examples. I wish I had more time. After a record number of Georgians voted by mail, SB 202 made it harder for voters to request a mail-in ballot, while also reducing the number of drop boxes to return them. I wonder why. It shortened the time for runoff elections, leading to fewer early voting days, which led to lines that were hours long. I wonder why. It allowed a single person, think about this, a single individual to make unlimited mass challenges to voters' registration. Who's changing the law in that case? Who's changing the way we've practiced our laws and the way we've allowed people to vote? A single individual to make unlimited mass challenges to voters' registration. And in 2022, this allowed just 6 right-wing activists to challenge the registrations of 89,000 Georgia voters. 100,000 voter challenges, 89,000 of them put forward by 6 right-wing activists. And they have not stopped there. This year, a member of the state election board proposed ending no excuse vote by mail. And a Georgia State Senate committee voted to end automatic voter registration. I find it very interesting that the folks who say we need to make sure that there is integrity in our system, and I believe in that, and who put forward voter ID, which I support. I think often it's too restrictive. But it's interesting that the folks who say we've got to make sure that we verify people's voter ID would show up as opposed to voter motor laws, where you're using the bureaucracy and the regiment of getting a driver's license as the basis for getting registered to vote. Why would you get rid of that if you believe in voter identification? Sadly, Georgia is not unique. Last year, lawmakers introduced over 350 restrictive voting bills in 47 states. Many of these efforts are only possible because of the gutting of the Voting Rights Act. Now, some argue that high voter turnout means there is no voter suppression. So let's talk about that. Let me be very clear. People across the country turned out in the rain and the cold and during hours-long lines, and not in every neighborhood, some neighborhoods. We're entitled to our own opinions, not our own facts. It's a fact that people of color, black people, stay in lines longer just to vote. But these people stayed in line not because there's no voter suppression, they just refuse to have their voices silenced. I saw this firsthand in 2022 when Georgia state officials tried to eliminate Saturday voting. They argued it wasn't allowed, in part because of a state holiday originally celebrating Robert E. Lee. And so I sued the state, and I won. They appealed, and I won again. We went all the way to the Georgia Supreme Court, where I won again. You would think that state election officials in Georgia would have been busy getting ready for the runoff election. Instead, they were spending our resources appealing the decision for folks to be able to vote on Saturday. I wonder why. 70,000 people voted that day. And if you only knew that number, you might think that voting is easy, as some of my colleagues want to suggest. What you would miss is how hard we had to fight for them to be able to show up. The fact that people voted does not mean all people had an equal opportunity to vote. And a recent analysis by the Brennan Center shows that since the 2013 Shelby decision, the turnout gap between white and non-white Americans has grown. We're all entitled to our own opinion. These are the facts. The racial gap has widened. And it has especially widened in the places once covered by the Voting Rights Act's pre-clearance requirements. In 1965 and over the decades since, Congress has repeatedly reaffirmed the Voting Rights Act on a bipartisan basis. In 2006, this very body reauthorized the Voting Rights Act by a vote of 98-0. President George W. Bush, a Republican, was president. Before us is the opportunity to advance that legacy by passing the John Lewis Voting Rights Advancement Act and the Freedom to Vote Act. The Freedom to Vote Act, which many of my colleagues here, including Senators Klobuchar and Padilla and I introduced, would create national minimum standards for voting, end partisan gerrymandering, and root out the influence of dark money. Meanwhile, the John Lewis Voting Rights Advancement Act would restore the protections of the Voting Rights Act, including preclearance, to prevent future attacks on our right to vote. This should not be a partisan issue. The right to vote is preservative of all other rights. It preserves the framework in which all debate takes place. These bills would ensure that every eligible American has a voice in the direction of our country, from working families who need to vote after hours to rural voters who need to vote by mail. In conclusion, and nobody believes a pastor when he says in conclusion, let me say that it's true all of us celebrate John Lewis. And a couple weeks ago, many folks made that annual pilgrimage to Selma. You cannot remember John Lewis and dismember his legacy at the same time. If you celebrate John Lewis, support what he supported. He supported the legislation in front of us. The Freedom to Vote Act was written by John Lewis. If you celebrate John Lewis, pass the John Lewis Voting Rights Advancement Act.
Thank you, Senator. Senator Graham, you may introduce your witness.
Thank you, Mr. Chairman. We're honored to be joined today by Representative Wesley Hunt. He serves as U.S. Representative for Texas 38th Congressional District. He was first elected in 2023 and serves on the House Judiciary Committee, as well as the House Subcommittee on the Constitution and Limited Government. He received his Bachelor of Science from the United States Military Academy at West Point. After serving 8 years in the United States Army, he attended Cornell University, where he obtained a Master's of Business Administration and Public Administration and Industrial Labor Relations. You're a busy guy. We're honored to have you. Thank you very much.
Thank you, sir.
Congressman Hunt, proceed.
Thank you, Chairman Durbin and Ranking Member Graham, for having me here today to speak about voting rights in America, the country that I love dearly. More importantly, I'm here to talk about the left's soft bigotry of low expectations. Because it's the Democrat Party, not the Republican Party, that thinks so little of Black America as the people of color that they make the case that being Black in America means we can't obtain a government ID to vote. And that's not only a ridiculous assertion, it's demeaning and it's insulting. When it comes down to it, many of my colleagues on the left like to pretend that we're still living in the 1950s. Well, we're not. I've got some good news for you. It's 2024, and I know what year it is because I've been Black for just over 40 years. And I'm also the son of a retired lieutenant colonel who grew up in the segregated South. You see, my parents grew up in a Jim Crow South in the 50s and 60s in New Orleans, Louisiana. Their next generation, my parents had 3 kids. My sister, brother, and I all went to West Point, all 3 of us. We all served our country in combat. And I sit before you today as a sitting United States congressman in a district in a suburb of Houston, Texas, that's a white majority district, that President Trump would have won by 25 points, and I won by almost 30 points. And that doesn't happen unless we've made some incredible progress in this great nation. Now, my colleagues on the left like to say that common sense voting laws, including requiring a government-issued ID, are racist, discriminatory, and burdensome. Do you know what my father had back in the 40s and 50s before it was even cool? A government-issued ID. And continuing in his footsteps, I too have multiple government-issued IDs, and while that might be shocking to many people in this country, people may ask, how's that happen? It's very simple. It's personal responsibility for all Americans in this country, regardless of what you look like. Sitting with me today is my global entry card, my military ID card, my Texas driver's license, my Texas license to carry, because that's how we roll in Texas, my congressional card, and of course, the good old-fashioned American passport. What sorcery is this? What am I, the Black Houdini? How was I able to pull off the impossible and attain not one, not two, not three, but 6 government-issue IDs? Personal responsibility in this country. I fought for this country as an Apache helicopter pilot to protect free and fair elections, and having a government-issued ID isn't racist, it's American. You need to have an ID to drive a car, to check into the airport, open a bank account. You need an ID for basically everything to be a responsible adult in this country, except for voting, apparently, according to the left. Black America does not need well-meaning liberals putting their arms around us and telling us how we should go to the polls. In fact, if you look at recent headlines and polls, you will find that black men specifically in this country are more fired up than ever to participate in the next presidential election. And I think I know why, and I'm really looking forward to these results. For the record, in the 2022 midterms in Georgia, it proved that election integrity and ballot accessibility can be achieved hand in hand. After the 2020 election, Georgia passed a voter election integrity law, and subsequently, the Department of Justice filed a lawsuit against the state of Georgia, alleging that the Georgia law is discriminatory and aims to restrict citizens from voting. President Biden even called this law, and I quote, Jim Crow 2.0. Really? In my humble opinion, referencing Jim Crow for common sense election integrity laws is offensive to those who actually experienced Jim Crow, like my parents and their parents before them. In fact, the law wasn't discriminatory at all, because in the 2022 midterms, Georgia voters shattered voter turnout records across the state. And despite that record-breaking turnout in Georgia, the DOJ lawsuit is still pending. I suspect that it's because that record-breaking turnout resulted in a Republican governor being elected in Georgia, but I digress. I'm going to say the quiet part out loud, which I tend to do. I have a lot of respect for John Lewis, but the John Lewis Voting Rights Advancement Act is not about protecting voting rights. It's about solidifying Democrat power nationally. It's about federal control over state and local elections, which, by the way, is unconstitutional. It's about diminishing the security of our elections. And voter integrity laws aren't discriminatory. They are required for a functioning constitutional republic. I'm going to tell you today, I categorically reject the soft bigotry of low expectations. Black Americans and people of color are proud. We expect more of ourselves. That's what Black excellence really means to me. And above all else, we don't need a new solution to a problem that doesn't exist. Let me be clear. Making it to the polls to vote in person with an ID in this country today is a very low bar, extremely low bar. We can do it, white people can do it, black people can do it, Americans can do it. And we should all want that for free and fair elections. If you want to be on the right side of history, you should reject the Democrats' party's attempt to wind the clock back 70 years. Because I'm sitting right here in front of you, and I'm here to tell you we've come a long way. Let's continue this progress. Thank you for your time. Thank you, Chairman. Thank you, sir, for having me.
Thank you, Congressman. We'll now switch to our second panel. If the witnesses for the second panel will start to come forward, we'll start shortly. I thank everyone for their patience. Let me introduce the majority witnesses. First, we welcome Damon Hewitt, the President, Executive Director of the Lawyers Committee for Civil Rights Under the Law. Mr. Hewitt has more than 20 years of civil rights litigation and policy experience, including prior leadership roles in the nonprofit, philanthropic, and public sectors, and he's led the Lawyers Committee since 2021. Also joined by Lydia Camarillo, I hope I pronounced that correctly, who serves as president of the Southwest Voter Registration Education Project, a nonprofit organization helping millions of Latino voters register to vote. Ms. Camarillo previously served as National Leadership Director for the Mexican American Legal Defense and Education Fund, MELDEF. Our final majority witness is Sophia Lynn Lakin, Director of the Voting Rights Project at the American Civil Liberties Union, where she leads a team of attorneys working to advance and protect access to the ballot. She has worked on many successful challenges to discriminatory voting laws across the country. Ranking Member Graham, would you please introduce your two minority witnesses?
Yes, thank you, Mr. Chairman. Our first witness is Hans von Spukowski. Is that close?
Thank you, Mr. Chairman. The claim that
wait
there...
a minute. Did I get your name right?
Yes.
Okay, good.
You did.
He's the manager of the Election Law Reform Initiative and senior legal fellow at the Heritage Foundation. He was appointed by President Trump to the Presidential Advisory Commission on Election Integrity in 2017. He is also has prior experience as member of the Federal Election Commission, an attorney with the Civil Rights Division at the Department of Justice. He is a graduate of Vanderbilt University School of Law and received a BS from MIT in 1981. Maureen Reardon, did I get that right? Thank you. Second witness, she is a litigation counsel at the Public Interest Legal Foundation. Over 20 years of experience of litigation with the Voting Rights Act and the Department of Justice. She holds her law degree from St. Mary's Law School and received her Bachelor of Science degree from Seton Hall. Thank you.
Thank you. If the witnesses would please rise to take an oath. Please raise your right hand. Do you affirm the testimony you're about to give before this committee be the truth, the whole truth, and nothing but the truth? So help you God. Let the records reflect that the witnesses answered in the affirmative. And we'll start with Mr. Hewitt. 5 minutes.
Good morning, Chair Durbin, Ranking Member Graham, and members of the Senate Judiciary Committee. My name is Damon Hewitt, President and Executive Director of the Lawyers Committee for Civil Rights Under Law. Thank you for the opportunity to testify this morning about the important need to protect voting rights by restoring the Voting Rights Act. The Lawyers Committee uses legal advocacy to achieve and advance racial justice, fighting inside and outside of the courts to ensure that Black people, people of color, and all Americans have the voice, the opportunity, and the power to make the promises of democracy that are on paper real in our daily experience. At the Lawyers Committee, we litigate cases on behalf of voters who are traditionally, historically, and today disenfranchised, voters who face the fiercest of voter suppression tactics. The Lawyers Committee also co-convenes the Election Protection Coalition, the nation's largest, oldest, nonpartisan voter protection coalition comprised of nearly 400 organizations. Our work gives us a front row seat to modern day voter suppression. We see up close the barriers that voters face, and we understand the challenges that litigators and advocates face in defending that right to vote, now over 10 years since the Supreme Court's decision in Shelby County versus Holder. As Chairman Durbin noted earlier, the late Congressman John Lewis said that voting is the most powerful, nonviolent tool we have to create a more perfect union. And as President Lyndon Baines Johnson noted when urging Congress to pass the Voting Rights Act, he said, there can and should be no argument. Every American citizen must have an equal right to vote. Senators, no eligible person of voting age, especially historically disenfranchised Black voters, should be confronted with barriers designed to make it more difficult for them to register and more difficult to cast a ballot. That's what this is all about. Nor should we be limited to participating in an empty ritual in which the ballots we cast are rejected or rendered meaningless by discriminatory procedures or redistricting practices, sometimes hiding under the guise of partisanship. Moreover, we should not be subjected to court decisions that systematically neuter the reach of longstanding civil rights laws. Yet, these things are happening with greater frequency due to the weakening of the Voting Rights Act. The floodgates of voter suppression have been wide open, and the health of our democracy has deteriorated with every passing election cycle. Over a decade since Shelby County, we know that the preclearance provision, which was so important, which allowed DOJ or a federal court to stop bad things from happening before they happened, The prophylactic power is what we're missing here. Justice Ruth Bader Ginsburg's famous dissent in Shelby County put it best, and it becomes more prophetic with each passing year. She said, throwing out preclearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you're not getting wet. Senators, voters of color are feeling the storm. Our country has gone from being protected under the umbrella of Section 5 to being drenched by wave after wave of voter suppression actions and tactics and laws at the state level. We are battered by headwinds from cases like Shelby County and Brnovich v. DNC and other cases that systematically cut back the scope and legal protections of the VRA. We are weathering the barrage of all of these state laws, all made possible by the gutting of Section 5, the heart of the Voting Rights Act. Our litigators face new challenges in defending the right to vote. Our election protection staff and our partners on the ground nationwide are working valiantly to help voters make it through the storm, but Congress must do its part. In the Shelby County case, the Supreme Court acknowledged that racial discrimination in voting continues to exist. Racial discrimination in voting continues to exist. That's an invitation from Congress to act. And Congress can and must act by passing legislation like the John R. Lewis Voter Rights Advancement Act in its strongest possible form. In the decades since Shelby County, Congress as a whole has been derelict in its duty to restore the law. This is not rewriting the law. This is restoring the law to its original intent and force. And ironically, Congress and this body on a bipartisan basis has repeatedly supported, reauthorized, and even strengthened the Voting Rights Act. So what's different now? As this body considers new legislation to protect voting rights, I urge you to think back to the reasons why the VRA was adopted and passed in the first place. States with large numbers of people of color continuously pass laws to make it harder to vote. They targeted black voters with surgical precision, coming up with ingenious devices to make it harder to vote. A maze of trap doors, even if the door itself wasn't physically barred. History is now repeating itself, unfortunately, once again. As the proportion of black voters increases, we're seeing more of these ingenious devices, these devious methods to prevent people from voting or just to make it harder to vote. The whole idea is to have a chilling effect on voter engagement, voter participation, voter turnout, all for the means of political power. When Congress passed the VRA in 1965, it knew it had a moral imperative. I urge this body to find that moral clarity once again. America deserves better. I welcome your questions.
Thanks, Mr. Hewitt. Ms. Reardon.
Good morning, Mr. Chairman, ranking members, and members of the committee. Thank you for your invitation to speak to you today. I'm an attorney with the Public Interest Legal Foundation, a nonprofit law firm that is geared toward promoting election integrity and preserving the constitutional right of states to administer their own elections. From August of 2000 until the Supreme Court decision in Shelby County versus Holder, my sole responsibility was reviewing changes in voting that were subject to preclearance. If passed, the proposed act will once again give tremendous power to partisan bureaucrats within the voting section over the election procedures of every state and locality in the country. I began my employment in the voting section just prior to the presidential election in the year 2000. And during the Florida recount, I personally observed attorneys within the section faxing and receiving faxes from the DNC in the Gore campaign in Florida. The DOJ Inspector General report entitled A Review of the Operation of the Voting Section of the Civil Rights Division is attached to my testimony, and it provides instance after instance of bad behavior by the section, often racially motivated. For example, when the voting section brought a case against an African American in Noxubee County, Mississippi, the section attorneys didn't agree with the prosecution. They engaged in horrific behavior and targeted a black paralegal, telling him he was not black enough because he had the gall to work on that matter. Abuses by the section have also been really expensive to the taxpayer. The Office of Legislative Affairs said that between 1993 and 2000, the voting section has been sanctioned well over $2 billion. For an example, in Johnson versus Miller, the section was sanctioned almost $600,000 for collusive conduct with attorneys from the voting section and attorneys from the ACLU in review of the Georgia State Redistricting Plan. In Kinston, North Carolina, they objected to a decision by a majority Black city council to dump partisan races. The logic of the objection was that Black voters in Kinston would not know who to vote for if the Democratic title was not next to their name. In North South Carolina, they objected to the annexation of two white people. They wanted to get into the town for sewer and water. They objected because the town couldn't show that they had annexed any Black individuals, despite the fact that none had applied. I'm also aware of the intentional targeting of the continued viability of a state senator in South Carolina's district in the review of the state's statewide redistricting plan. Section 5 was a temporary provision, and their reason for it no longer exists. The Supreme Court in Shelby not only determined that the formula for Section 5 is unconstitutional, but it also questioned the need for it today. It made clear that only rampant discrimination on a wide scale would justify any formula for Section 5. The court acknowledged the onerous burden that pre-clearance process places on a jurisdiction, and it will doom the constitutionality of this act's addition of a retrogression claim under Section 2. Attempts by some to use the retrogression standard disguised as a claim under Section 2 has already been rejected by the Supreme Court. And furthermore, retrogression is not unconstitutional. Even the Department of Justice recognizes what's known as unavoidable retrogression. And this happens when the area of Black population moves, or there's been an influx of white population, or the minority population has become so infused within the county that it is no longer able to either maintain a minority district or create one. Those types of retrogression are not actionable under Section 5, and they certainly will not be actionable under Section 2. The department already has a history of weaponizing the retrogression standard. When they disagree with a voting change, they will use minuscule statistical differences to claim retrogression. The department's objections to South Carolina's voter ID law, based upon a 1.6% difference in white voters and Black voters' possession of an ID, is a prime example of this type of nonsense. The states previously covered by Section 5 will also be targeted again by your formula, which reaches back 25 years. 25 years ago, there were only certain states that were subject to the Section 5 preclearance standard. Those states had to submit every single voting change to the Department of Justice or the federal court. Therefore, they're the only ones that will have a history of violations. Simply put, the act and the formula will not survive judicial scrutiny. Thank you.
Thank you, Ms. Reardon. Ms. Camarillo, did I pronounce that correctly? Perfect. Please proceed.
Good morning.
You have to punch the button on the microphone.
Good morning, Chairman Durbin, Ranking Member Graham, and the U.S. Senate Judiciary Committee. Thank you for this opportunity and the honor to testify before the U.S. Senate Judiciary Committee. I come before you in strong support of the John Lewis Voting Rights Advancement Act, and I thank you for this important legislation. I am president of Southwest Voter Registration Education Project. I have had the privilege of serving in leadership positions at Southwest Voter for over 25 years. I have served as the chair of the Texas Latino Redistricting Task Force since 2010. Southwest Voter is a nonpartisan, nonprofit organization founded in 1974 in San Antonio, Texas by the late William C. Velasquez. Since opening its doors 50 years ago, Southwest Voter has registered 3.4 million Latinos. No other Latino or non-Latino group has registered more Latino voters than Southwest Voter. Southwest Voter has trained over 150,000 Latino leaders. As William C. Velasquez began work in Latino communities across the Southwest, he sought technical assistance from John Lewis while he worked for the Voter Education Project. William Velasquez gained the knowledge and skills he needed to register Latino voters from this legendary icon, our hero to all of us. In my role at Southwest Voter, I have witnessed states' enactments of laws to suppress and dilute votes, particularly of Latino voters and of other racial and ethnic communities. I have witnessed the systematic damaging impact of such legislation, among other factors, repair of efforts to suppress the vote is costly. In Georgia, in 2020, Southwest Voter contacted over 200,000 Latino, Black, and other ethnic voters whose ballots had to be cured to ensure their votes would be counted. In 2021, Southwest Voter reached out to over 50,000 Latino voters with live contacts to ensure that they could exercise their right to vote in the runoff elections for the U.S. Senate. My perspective is also personal. Over several election cycles when I voted, my precinct, located in a majority white neighborhood, I am told that I am not registered to vote. I have lived in my home since 1996. This is consistent with my observation that voter suppression efforts often target Latino communities based on the assumption that if the communities included Spanish speakers, they consist primarily of undocumented immigrants. I have seen dozens of voter suppression laws that target relatively recent Latino immigrants who are U.S. citizens, as well as U.S. citizens whose families have lived here for generations, indeed, since 1948. These are 12th-generation Americans. My perspective and that many of these laws represent serious deprivation of the right to vote and has confirmed by Southwest Voters' history of prevailing lawsuits. Southwest Voter has won 210 vindicating the right of Latino voters in multiple states. For example, in 2019, Texas was blocked by an SVRP lawsuit from perjuring 100,000 Latino voters from the voting rolls based on outdated driver's license or state identification information. These voters received their driver's license before they naturalized, but registered to vote after naturalization and voted lawfully. Efforts to make it difficult, if not impossible, for Latino voters to exercise their voting rights have been dauntingly successful. The Latino community makes up 40.2% of the Texas population, while the non-Latino white community comprises 39.8% of the Texas population. Yet there are 27 non-Latino white majority districts and only 7 Latino majority congressional districts in Texas. The John Lewis Voting Rights Advancement Act provides an essential legal framework to stop discriminatory changes in election law before they can be implemented. The act will help vindicate the right to vote in marginalized communities, particularly in states with large Latino populations. We urge the reinstatement of Section 4B of the Voting Rights Act and strengthen the VRA to help save America's democracy by protecting the right to vote for all citizens. In the past, Latino voters were blocked from voting by the poll tax. When the courts ruled this pattern of discrimination unconstitutional, the laws continue to be enacted to suppress and dilute the political power of the Latino electorate and others. Literacy tests, English requirements, and long residence requirements, to name a few. Over the last year, 19 states have enacted 34 laws to restrict access to voting. This includes obstacles to vote by mail, new voter ID laws, proof of citizenship, and limitation to voter assistance, especially for those with limited English or Spanish-only speaking, visual impairment, and voters who need assistance when voting due to disabilities or age. For example, Texas counties eliminated early voting sites and reduced days and hours of operation, particularly in voting in Latino communities. I urge the support of this bill, the John Lewis bill. We need it. Southwest Voter stands ready to vote, to work with the U.S. Senate Judiciary Committee to make sure that we move forward to ensure that we protect the right of every voter to vote. Thank you.
Thanks for your testimony. Next is Mr. Hans von Spakowski.
Thank you. Thank you, Mr. Chairman. The claim that there is a wave of voter suppression going on across the country that requires expansion of the Voting Rights Act is simply false. Efforts to enhance the integrity of the elections through reforms such as voter ID and improvements to the accuracy of voter registration lists are not voter suppression. On voter ID, for example, the data is very clear that such a requirement does not prevent eligible individuals from voting, and yet the proposed legislation would treat it as a suspect discriminatory practice. A 2019 survey by the National Bureau of Economic Research of 10 years of turnout data from all 50 states found that state voter ID laws, quote, have no negative effect on registration or turnout overall or for any group defined by race, gender, age, or party affiliation. Voters understand this. Polling shows they overwhelmingly support common sense voter ID requirements regardless of their race and regardless of their party affiliation. The Census Bureau reports that the turnout in the 2020 election was 66.8%, just short of the record turnout of 67.7% of voting-age citizens for the '92 election. The Census survey shows that there was higher turnout among all races in 2020 when compared to 2016. And the Census Bureau also says that voter registration in 2020 was higher than the 2000, 2004, 2008, 2012, and 2016 elections, when supposedly all this suppression was going on to keep people from registering. A survey after the 2022 election in Georgia shows that critics of the state's 2021 election reforms were wrong. The University of Georgia found that precisely 0% of black voters said they had a poor experience voting in 2022. And according to the Pew Research Center, Georgians cast more votes in 2022 than in any other midterm election in its history, with black voters making up 48% of the increase since 2000. In fact, in the 2020 election, when we were dealing with a pandemic, we had, according to the Census Bureau, the highest voter turnout of the 21st century. Yet S4 would actually expand preclearance to reach every state in the country with a new practice-based preclearance requirement. As the Supreme Court has made clear, any requirement that states obtain federal pre-approval of election changes could be imposed only if Congress found blatantly discriminatory evasions of federal court decrees, lack of minority office holding, voting tests and devices, or voting discrimination on a pervasive scale. Those conditions are nowhere to be found in 2024. The provisions of S4 that overturned the Supreme Court's guidance in the Brnovich decision on the application of Section 2 are also ill-advised and interfere with states' constitutional authority over the administration of elections. S4 eliminates rational and fundamental factors that are essential to evaluating the totality of the circumstances in any Section 2 lawsuit. It also specifically amends Section 2 to include a coalition of different racial or language minority groups. This would change the Voting Rights Act from a statute intended to prevent racial discrimination to a partisan tool to protect political alliances and coalitions. That would raise serious constitutional questions over the validity of Section 2. Existing federal laws are more than sufficient to protect voters and ensure that they can easily and securely practice their franchise without discrimination, fear, or intimidation. Americans today have an easier time registering and voting securely than at any time in our nation's history, and election officials and voters are already protected from intimidation, coercion by comprehensive federal and state laws. There is simply no need to implement a new, vastly expanded Section 5. And the changes proposed in Section 2 would change it from a provision to prevent racial discrimination in voting to a tool for political manipulation of redistricting and the voting process intended to guarantee the success of one specific political party. It is not 1965, and there's no longer any justification for giving the federal government the ability to veto election laws that citizens and their elected representatives choose to implement in their respective states. There's also no justification for eliminating the ability of states to defend themselves from meritless lawsuits filed under Section 2 for non-discriminatory, widespread, traditional election practices that have been developed to ensure both access for voters and safe, fair, effective, and secure administration of elections. Thank you.
Thank you, sir. Ms. Lakin?
Chair Durbin, Ranking Member Graham, and members of the committee, thank you for the opportunity to testify today. I'm Sophia Lakin, the director of the ACLU's Voting Rights Project. Last week, on the 59th anniversary of Bloody Sunday, we honored John Lewis and the civil rights activists in Selma, Alabama, who risked or gave their lives to secure the right to vote. Their courage, sacrifice, and determination led Congress to enact the Voting Rights Act, or the VRA, one of the nation's most successful pieces of civil rights legislation. But nearly 11 years ago, in Shelby County versus Holder, the Supreme Court gutted the VRA's most powerful provision, the preclearance system that stopped discriminatory practices before they took effect in places with the worst records of discrimination. This decision unleashed a flood of discriminatory voting laws across the country. Nearly 100 restrictive voting laws have been enacted since Shelby, and just this past year, at least 14 states have enacted 17 restrictive voting measures. Over the past 2 years, courts have struck down racially discriminatory maps in Alabama, Georgia, Louisiana, South Carolina, and elsewhere. The ACLU and our many partners continue to utilize case-by-case litigation to protect voting rights. For its part, the ACLU has filed or intervened in nearly 100 cases to protect the rights of voters in Shelby. But this approach, including using what remains of the VRA, particularly Section 2, a nationwide ban on discriminatory voting practices, is woefully inadequate to address the enormity of the problem at hand. For one, unlike preclearance, voters can bring Section 2 cases only after a jurisdiction passes a discriminatory law. It also requires vast amounts of resources and time. As we know firsthand, this too often allows states to keep discriminatory rules in place during elections against the backdrop of slow court processes, irrevocably disenfranchising the very voters the VRA was designed to protect. The ACLU's 10 active Section 2 cases have been pending on average for 25 months, more than a 2-year federal election cycle. I want to highlight one potent and very recent example, undeniably showing that racial discrimination in voting is very much alive and well today. The only appropriate response is to restore and strengthen the VRA, including preclearance. In 2021, along with the Legal Defense Fund and partners, we challenged Alabama's discriminatory congressional map within days of its enactment and won an injunction blocking it 9 months before the 2022 midterms. But even though the 3-judge trial court held that the case was not particularly close, the Supreme Court put that ruling on hold during appeal. Ultimately, in its landmark ruling in Allen versus Milligan less than a year ago, the Supreme Court agreed that the map discriminated against Black voters, violating Section 2. That's 11 years after a Supreme Court majority wrongly declared that things have, quote, changed dramatically in the South. In Alabama, the very state from which the Shelby decision arose. But it took 16 months to achieve this win. And in the meantime, the 2022 congressional elections took place under the racially discriminatory map. It is impossible to remedy the gross injustice Black Alabama voters faced, having their voting strength illegally stifled despite every effort under what's left of the VRA. This is an egregious affront to the promise of democracy John Lewis and other civil rights giants marched and bled for. And even after the Supreme Court finally agreed that Alabama's map was racially discriminatory, the state drew a new map that defied the judiciary and continued to discriminate against Black Alabamians, trying to yet again appeal to the Supreme Court. And the fight in Alabama continues as I speak. While a new map is in place for the 2024 elections, Alabama persists in defending its discriminatory map for future elections. This is one example among many, and we cannot stand by any longer while Black, Latino, Asian American, Native, disabled, and other marginalized voters continue to be silenced. The promise of a fully inclusive, multiracial democracy hangs in the balance. Our current tools in this fight, while important, are simply not enough to combat enduring racial discrimination in voting. Congress must meet this moment by passing the John R. Lewis Voting Rights Advancement Act. Thank you, and I look forward to your questions.
Thank you, Ms. Lakin. We'll go the first round, and members each have 5 minutes of questions. Let me say at the outset, thank you for being here and being part of this historic congressional hearing. But I do want to say, before we congratulate ourselves too much about 60% of the American population voting, we ought to take a look at some European countries, which have much higher percentages. For us to be satisfied with 60%, I think should be an embarrassment to us and not a source of great pride. We can and we should do better. Every eligible American should be voting. We should give them that opportunity, and that means making certain that the voting procedures are realistic. The University of Maryland teamed up with the Brennan Center and did a survey that they recently released of 2,386 respondents nationwide. When it comes to the issue of voter ID, what they found, I think, is very eye-opening. Congressman Hunt earlier brought in 6 or 8 government-issued IDs and to demonstrate how easy it is to get a voter ID. They included, of course, the obvious driver's license, but went on to include passports, global entry, and other things. If you're aware of those systems, you know that they're not free. You end up spending money to obtain that government ID. And it's understandable that lower-income individuals are less likely to be in that position. The Brennan study with the University of Maryland found some interesting things as well when it comes to the easiness of using the driver's license as a voter ID. 21 million voting-age U.S. citizens do not have a current driver's license, 21 million. Another 12% have a non-expired license, but it does not have both a current name and a current address for that voter. 96% of those with some discrepancy have a license without a current address. So you move and you don't change your driver's license. In many states, you can't use that as your ID to vote. When you look at subsets affected by this, younger Americans, 41% of those between 18 and 24, currently don't have a driver's license with a current name. Young Black Americans, 47%, neither current name or address. 30% no license at all for young Black Americans. So to say this is an easy thing is not realistic. And of course, when they do the analysis, people with less education and lower annual incomes are more likely to lack a current driver's license. To say that this is somehow the bigotry of low expectations, I think, is insulting. These individuals, many of them are just living difficult lives with a lot of demands. Ms. Lakin, have you run into this in your analysis of the use of voter ID?
Yes, Senator, thank you for that question. Absolutely. And when it comes to voter ID, I would say the devil is in the details. While we all agree that elections should be safe and secure and free and fair, and that voters should be verifying that identity, the truth of the matter is that in many instances, there are voter IDs that are really difficult to comply with, and that they are adopted with discriminatory intent and with discriminatory impact. And we have seen this, for example, in the North Carolina case that we litigated in 2013, which was challenged a law that was adopted shortly after Shelby County. In that case, the state, following Shelby County, went ahead and changed the voter ID law that it was going to impose, and in doing so, dropped IDs that were disproportionately held by Black voters, and left in the bill only those voter IDs that were disproportionately held by white voters. Ultimately, the Fourth Circuit ruled that the law targeted Black voters with almost surgical precision and struck down that law as unconstitutional.
I think those were the exact words used by the court in North Carolina. Is that correct?
That's correct, Your Honor, Senator.
We call him His Honor all the time. It's fine.
I'm a litigator.
Go straight to
Hard
me.
habits to break.
Mr. Hewitt, I guess they're telling us that we're living in the past. We seem to think this is still Jim Crow America and things are much better off. And yet, since the Shelby decision, we've taken a closer look at the changes in state laws. And what do we find?
What we're finding is the same type of surgical precision or attempts proximate to that. You know, I know as a native of New Orleans, in the great state of Louisiana, the state where since the Voting Rights Act was adopted, every redistricting plan for the Louisiana House of Representatives was rejected by DOJ or federal court because it undermined black voting strength. And that pattern would have continued but for Shelby County and the gutting of the pre-clearance provision. We see the same patterns that we've been seeing for a long time. And also growing up in Louisiana, I know that in black communities, certainly in my home state, people in black communities tend to vote in person. That's how we did it. But during the pandemic, when there were new methods of voting, newly available or newly popularized, absentee or by mail, or in even Harris County, Texas, drive-through voting, which is in-person voting, but drive-through voting, what we saw is as soon as black voters started using those methods, all of a sudden they became a problem. All of a sudden there's some type of issue. It's that kind of surgical precision that underlied our desire and in fact, our action to file intentional discrimination claims in cases like we did in Georgia, challenging SB 202. Because if you're challenging the very means that are newly popular with black voters, you must have a problem with those black voters. And so these patterns are repeating themselves over and over again.
Thank you very much. Senator Lee.
Thank you, Mr. Chairman. Thanks to all of you for being here to testify on this important issue. I'd like to ask each of you a couple of very simple questions in the interest of time, because we've got a lot to cover and little time to do it. I'm going to ask for a yes or no answer to each of these questions. What I'd like to do is start with Mr. Hewitt and then go to Ms. Riordan and so on and so forth. Again, answer with a yes or a no. So we'll start with you, Mr. Hewitt. Do you believe that only citizens of the United States should be able to vote in federal elections?
We don't have a position about non-citizens voting in federal elections. We believe that's what the current laws are, and so we're certainly fighting for everyone who's eligible under the current laws to be able to vote.
Ms. Riordan?
Yes, I do not believe they should be able to vote. Oh, sorry. I do not believe that non-citizens should be able to vote in federal elections.
Ms. Camarillo?
That's a decision of the state law, but I want to emphasize that.
It's a decision of state law as to who should vote in federal elections?
States decide who gets to vote in various elections. And in federal elections, I believe that we should be encouraging people to naturalize and then vote.
Okay, but you're saying that the federal government should have no say in who votes in a federal election?
I don't have a position on that.
Mr. Von Spakovsky?
As a first-generation son of naturalized citizens, I believe only citizens should be allowed to vote in all U.S. elections.
Ms. Lakin?
Federal law prohibits non-citizens from voting in federal elections, and we support, our work focuses on enabling all eligible voters to be able to vote and cast their ballot and have that ballot counted.
Okay. Now, here's the second question, and again, please give me a yes or no if you possibly can. Do you believe that people who are registering individuals to vote, I'm sorry, do you believe that people registering to vote should provide documentary proof of their citizenship in order to register to vote? Mr. Hewitt?
I think your first question kind of answers the second. Based upon the applicable rules, federal or state elections, or what have you, we know we have to follow those rules. The question is, what's the impact of those rules?
Ms. Riordan?
Yes.
Ms. Camarillo?
Voter registration cards and affidavits, when people sign them, people are signing under federal, penalties of certain, depending on the state, either criminal or otherwise.
Yeah.
That they're.
Can I get a yes or no out of you? Should
I'm
they or
sorry?
should they not have to require documentation establishing their citizenship?
It's already redundant in many states, and it's already being asked.
Mr. Von Spakovsky?
Yes, all individuals should be required to provide proof of citizenship.
Ms. Lakin?
Documentary proof of citizenship requirements are often discriminatory. In fact, we sued the state of Kansas and won litigation on this issue.
Okay. I do find it troubling that these couldn't both all be answered with a simple yes. I think if you asked most Americans, overwhelming majority of Americans would say, yeah, you should have to be a citizen to vote in a federal election, and yeah, you ought to be required to prove it. You have to show identification papers when you board an airplane. unless you're an illegal alien, of course, but that's a different question. To go to the doctor in many instances, to pick up a prescription in many instances. All kinds of things require identification. Why not voting? Now, the Carter-Baker report from 2008, keep in mind that the Carter and Carter-Baker, as former President Jimmy Carter, recommended that states require voters to use a real ID compliant identification to, quote, ensure that persons presenting themselves at the polling places are, in fact, the ones on the registration list. And I agree with former President Carter on that. And to that end, I've authored legislation that would allow states to enforce such identification laws, which are so popular among Americans, and with good reason. The legislation, as compared to the likely unconstitutional John Lewis Voting Rights Advancement Act, would respect the boundaries of federalism. And that's important always that we do that, in that that's one of our twin structural safeguards in the Constitution. Mr. Vonsky-Pukovsky, in your experience, would more robust voter ID laws disenfranchise legal voters?
The answer to that is no, and that's not my opinion. That's based on turnout data that we now have for more than 15 years, election after election after election. Georgia, for example's ID law has been in place since the 2008 election. They've seen record registration and turnout of all voters, including Black and Hispanic voters there. And all the studies, one of the ones I cited, showed that when you compare all 50 states, IDs do not keep people from voting, particularly because every state that's put in an ID requirement will provide a free ID to anyone who doesn't have one.
Thank you. Thank you, Mr. Chairman.
Senator Klobuchar.
Thank you very much, Mr. Chairman. Thank you to our witnesses today. Ms. Camarillo, you testified that just last year alone, over 19 states enacted laws to restrict access to voting, making it more difficult for people, specifically, in many instances, people of color, to vote. Could you talk about which voting restrictions you've seen that particularly impact people of color?
Well, I think that the restrictions for voting are in Texas particularly. I think we find that some voters are not able to vote because they cannot have an assistant. They're not able to vote, and by an assister, they call it an assister. These voters need to take someone because they cannot read, they don't speak the language, or they're visually impaired, or they simply need someone to help them maneuver the voting system, and that is no longer allowed. We found that when SB 1, which is the case that I'm referring to, many voters were confused, were scared that they were not going to be given an opportunity. And there's also a partisan piece where partisans can walk into the booth to where you're voting and stand in front of your face and tell and intimidate the voter. It's a strategy to intimidate the voter.
Okay.
That's one. I've also seen where voters have, I'm sorry, you were going to ask.
No, go ahead. I just have a few more. Go ahead, quick.
I've also seen where voters have not been able to go to the precincts because they don't have a right. They move the precincts, the voting sites from their neighborhoods to other places that are far, and they don't have a right.
I saw that in Georgia when I went down there, when we had our voting rights hearing with the Rules Committee down there. They move it.
Correct.
In Georgia, there was a different polling place for one voter from the primary to the general election to the special election. So, exactly.
There's also tactics that we can't truly document that I recorded in my written testimony, and it's part of my experience where someone will show up to vote and they're being questioned. There's a woman in Florida that was Southwest voter registered to vote, and she was told that she did not register in time to participate in that particular election cycle, when in fact she had registered to vote in August. Mm-hmm. So I'm concerned about laws that are in the books that are hurting people to have the right to vote and exercise the right to vote. I'm concerned that there's an attack on the Latino community, think then that we're all undocumented. And in fact, as someone who registers voters and trains people to register voters, and we have registered 3.4 million people. I can tell you that voters that are not citizens will tell you, I'm not a citizen, because they don't want to create any problems.
Okay, thank you.
Thank you.
Very much. Mr. Hewitt, when Senator Warnock was speaking, he mentioned the Freedom to Vote Act. As you know, there are a number of bills in there that would supplement the John Lewis Voting Rights Act, including the Same-Day Registration Act, something that has led Minnesota year after year after year to have the highest voter turnout in the country, a number of voter turnout, including with our minority communities that a lot of states would like to see. The Save Voters Act prohibits states from unfairly purging people from voting rolls. Do you agree that in order to protect Americans' right to vote, we need the John Lewis bill and also the Freedom to Vote Act? And could you talk a bit about the Freedom to Vote Act?
Sure. I know there's a hearing, obviously in Senate rules later today about freedom to vote.
Thank you for giving us a pre-advertisement
There you
for
go.
that.
There you go. And I'll be there to visit with you all. But, you know, we came to the understanding in the civil rights community that there is a double value to having the John Lewis Voting Rights Advancement Act and the Freedom to Vote Act, which some people say is a law just about election administration, but it's really about, it really mirrors in many ways the John Lewis bill, because the John Lewis bill and the VRA itself is about all of these kind of death by a thousand cuts, these things that seem innocuous, that seem facially neutral, that seem little, that lead to voter disenfranchisement. And that's how I think about the Freedom to Vote Act. You know, when we think about election administration, about all of the provisions of that bill that really make it easier for people to vote, right? So if the John Lewis bill is about how we should not make it harder for people to vote, the Freedom to Vote Act is about how do we make it easier for people to vote in a safe way, in a righteous way, in a way that's entirely legal and lawful. And so I think that the twin force of those bills really is the call, the invitation to Congress and to the Senate in particular to act.
Thank you very much.
Thank you, Senator Klobuchar. Senator Graham?
Thank you, Mr. Chairman. Mr. Sputkovsky, what would you say this legislation's about? What do you think the goal of this legislation is?
Well, bringing back preclearance is to give the very partisan bureaucrats inside the voting section where I first worked when I got to the Justice Department, basically control over state elections. And a lot of groups don't want to have to go to court like other litigants and actually prove a case, prove discrimination. They would rather be able to call their friends and former colleagues who are now working in the voting section say, you know, we really don't like this particular bill, you should object to it. And that's the kind of thing that Ms. Reardon and I saw happening when we were there.
Ms. Reardon, you gave examples of this part of the Department of Justice being sanctioned. You know, in simple terms, it seems to be that people in this section are more on a political crusade than they are enforcing the law. Is that a fair statement?
That's definitely a fair statement. My very first day in the section, when I was being walked around and introduced, there were political, campaign-type signs for the Gore-Lieberman ticket. It was in the year 2000. Obviously, infraction of the Hatch Act. When Barack Obama won the election in 2008, I come in very early in the morning. Somebody had smashed the picture of George W. Bush and taken a picture of Barack Obama out of like the newspaper and pasted it to the frame. There is, if they don't like the politics of a particular state, they target them. There were signs on doors that said, "Mess with Texas." It is very, very political. I was shocked at how political it is.
Yeah, well, I guess we shouldn't be. Are you familiar with the case of Kim OGG? I can't say her last name. I don't want to butcher it. The Democratic District Attorney in Harris County, Texas. She went to vote, but she was turned away because her ballot had already been cast. Are you familiar with that?
I heard about that on the news.
Yeah, so this is the district attorney for a county in Texas, so the idea that we want to preserve the integrity of the ballot box, I think, is real. Mr. Spitkovsky, at the end of the day, the Supreme Court decision regarding pre-clearance was based on evidence that states in question had advanced. Is that correct?
That's exactly right, and in fact, remember, Section 5 was put in when voter registration and turnout of African Americans in the covered states, places like Alabama. I mean, look, they were the subject of systematic, widespread discrimination. So their registration turnout rates were extremely low. But when the Supreme Court got this decision, Congress wanted to renew this bill based on 40-year-old data. They didn't want to renew it based on current registration and current turnout rates, because if they did, not only were the covered states as good as uncovered states, many of them were far superior. I just did a study on this, and for example, in the 2016 election, every one of the formerly covered states, with the exception of Texas, had a higher registration rate than the state of New York. In the 2020 election, 6 of the 9 pre-clearance states had higher registration than New York, and 4 had higher turnout. New York, as you know, never been covered, but the point is, there's no longer any radical difference between the formerly covered states and the rest of the country. In fact, they do better than many other states.
So if the data is that clear, then why are we trying to do what we're doing, Ms. Reardon?
I believe we're trying to take the states' rights from them and federalize all elections and hand a lot of those decisions to partisan bureaucrats within the Department of Justice.
I think you're right. Thank you, Mr. Chairman.
Senator Coons?
Thank you, Mr. Chairman, and I'd like to thank all of the witnesses who are here with us today. Former Congressman, late Congressman, John Lewis was a personal friend, and I was blessed to have the chance to cross the Edmund Pettus Bridge with him on several occasions, to stand at that bridge at the 50th anniversary and to hand to several of my colleagues a copy of what is now known as the John Lewis Voting Rights Restoration Act, and to press them to consider co-sponsorship. I work closely with our former colleague, Senator Leahy, on this legislation. I am from a state, Delaware, which has a long history of actually making it hard to vote. And where in Delaware we have tried several cycles now to work to improve things like mail-in voting, same-day registration, and where it is actively being litigated. It is a contentious issue. Everyone seems to agree that John Lewis was a towering figure in the American Civil Rights Movement and that his legacy needs to be maintained. In fact, it was one of the very few moments in the State of the Union speech, Mr. Chairman, where members of both parties stood and applauded when he was recognized by our president. Yet what we should be doing going forward seems strikingly divisive. In the few minutes I've got, let me, if I could, Mr. Hewitt, just ask you, since the Supreme Court's decision in Shelby County, we've seen restrictive voting laws crop up all over the country, including some states covered formerly by Section 5. In 23 alone, more than a dozen states enacted newly restrictive voting laws. Why did the Supreme Court's decision, briefly, make it more difficult to challenge these laws? And if it became law, how would the John Lewis Voting Rights Advancement Act protect against restrictive voting laws?
Well, in the covered jurisdictions, the Shelby County case made it such that we no longer have in this nation the benefit of the prophylactic power, the power to stop these negative laws, these bad laws from being implemented before they cause harm. But also, there's other damage being done as well, Brnovich v. DNC, and there's even also a case right now suggesting that there's a right without a remedy, that there's a right to not be discriminated against, but no right of private action, so to speak. And so I think Ms. Lakin may have spoken to this earlier, but Section 2 litigation is not only time-consuming, but it takes so long that the damage will be done often before we actually get relief.
Mr. Hewitt, if I could briefly ask one other question. In many hearings on this topic over many years now, I've heard concerns and complaints about voter fraud, widespread voter fraud, being used as the reason to advance some of these restrictive laws. How many cases are there of voter fraud in our elections?
The numbers are infinitesimally small. They're typically not associated with the voters who are pleading with greater access. And really, the fraud squad, as some people call it, they're really, you talk about a solution in search of a problem, that's exactly what this fraud squad is. They search high and low for instances of voter fraud, and they even try to entrap voters in the case of Florida into saying, you can vote now, but we got you. Now we're going to hold you subject to criminal sanctions.
Well, I'll say this. The integrity of our voting process is an important matter for all of us. I was a county elected official. Many counties across the country administer the election process. I do think voting integrity is important. But the point is, out of billions of votes cast, there are just a handful of examples of voter fraud. I wish this were a bipartisan issue. It was when the Voting Rights Act was first enacted, and it was every single time it was reenacted for many, many years. Let me turn last to a concern that I think is timely and relevant, and where there's bipartisan legislation being led that could help forestall a very real possible challenge to our next election. We've got the very real possibility that artificial intelligence-generated deepfakes, which have been deployed across the world, recently had an impact in an election in Slovakia that changed the outcome, had a potential impact in the Taiwanese elections where they were widely deployed. In New Hampshire, on primary day, an AI-generated robocall of President Biden's voice encouraged New Hampshire residents not to vote in the primary election. Our own election is just months away, and I think we need to act now to protect against the predictably harmful effects that deceptive AI could have on our democracy. Senators Klobuchar and Hawley, Collins and I have introduced a bipartisan Protect Elections from Deceptive AI Act, which would ban the use of materially deceptive AI-generated voice or audio of a candidate for federal office in a way that would impact the election or steer contributions. Ms. Laskin, do you agree that AI does in fact pose some threat to our elections?
Senator, I think that the risk of misinformation and confusion is very real, and that voters need to have accurate, correct information in order to be able to participate in our democracy.
Given that there are very, very few cases relative to the number of votes cast of actual voter fraud, but there have been demonstrated cases of foreign nations attempting to interfere in and influence our elections, and there's recently been a national election determined, influenced significantly by a deepfake AI. Do you think it's important for us to pass bipartisan legislation like the Protect Elections from Deceptive AI Act before our own elections this fall?
It's certainly a concern that this Congress should be looking at very, very closely.
Thank you, and thank you to all the witnesses today. Thank you, Mr. Chairman.
Thanks, Senator Coons. Senator Grassley?
Hans, I'm going to start with you. The goal of federal elections is to ensure that every U.S. citizen who is eligible and registered to vote should have the opportunity to cast a vote in an election if they so choose. Americans need to have confidence in our elections. The integrity of our elections is paramount to confidence in our democracy, and the votes reflect the voice of the American people. So what safeguards are in place to ensure ineligible non-citizens don't end up on the voter rolls, and are current measures in place to satisfy this position?
Well, unfortunately, there aren't a lot of safeguards in place. I mean, one of the only ones around is what's called the SAVE system. That's a database at the Department of Homeland Security. It's the same database employers can check with and state agencies can check with to make sure that someone is a citizen, someone is entitled to apply for welfare benefits. The problem has been for many years that DHS has thrown up red tape and made it almost impossible for election officials to be able to consult the SAVE database to check the citizenship status of individuals on the voter registration list. About the only other thing states can do, because they're not requiring proof of citizenship and there's some bad law on that, is to use jury information. A great amendment to the NVRA would be, right now the NVRA requires all U.S. attorneys to notify state election officials if someone is convicted of a felony in federal court in order the state to be able to take that into account if felons are not able to vote. A great amendment would be to say that all federal courts have to notify state election officials when an individual is called for jury duty and is excused because they're not a U.S. citizen. Why? Because the courts get their voter lists from state election officials. They use voter registration lists. But other than that, there's hardly anything out there states can do to check this.
Hans, do you think that the John Lewis Act would be constitutional or unconstitutional by the courts?
Oh, I think it would raise serious constitutional questions about the validity now of Section 2 if the changes are made, and I don't think that the bringing back of Section 5 meets the standards that have been laid out by the Supreme Court for showing widespread, systematic discrimination that would justify treating some states differently than others, or justifying federal control over what is, in essence, state sovereignty and the state ability to administer their elections.
Ms. Reardon, I'd like to have you comment on a question that another witness spoke to. If this voting rights bill were to become law, so-called preclearance would be reinstated. Can you explain why preclearance is problematic here and why Section 5 was meant to only be temporary?
Sure. Well, I think the Shelby County decision is illustrative of the issues. As Mr. Von Spakowski has already stated, during that case, the Supreme Court said that Section 5 was temporary, and it was temporary for a reason, right? Because we no longer have rampant discrimination in this country, and we no longer have evasion of court decrees, which is what was happening, during the time that Section 5 was imposed. If we redo this formula, if the Senate does this and it passes, and it goes back to the Department of Justice, there will definitely be a weaponization of the preclearance process by the Department of Justice. They've done it for the 20 years I was present at the office, so I don't have any reason to believe that that's not going to continue. And if this rampant discrimination that everyone talks about actually exists, why is it then that the Department of Justice has only brought 9 Section 2 cases since the Shelby County decision? They are supposed to be the one group that has the, the foresight and all of the money of the federal government to bring these Section 2 lawsuits that are so expensive, yet there's only been 9 since 2013. That's not even one a year.
Isn't it ironic in the 2020 election, the massive increase we had turned out in the election, and then to hear complaints about voter suppression? I yield the floor.
Senator Welch.
Thank you very much, Mr. Chairman. Mr. Van Spakowski, do you think that the 2020 presidential election was rigged?
Senator, that election's over with. There were no cases proven in court to show that it should be overturned, as happened in for example, the 2018 congressional race, the Ninth Circuit. So what we should be doing is looking forward to try to fix the vulnerabilities that we do know exist in the system.
So what's your answer?
I just gave you an answer. Joe Biden is the president. He was certified as the president. There were no cases in court proven to show that there was the kind of fraud that would have overturned the election. That's the way that, as you know, it works. In the Ninth Circuit in North Carolina, that happened.
So the 2020 election was not rigged.
Was what?
Not rigged.
I've given you my answer on this, Senator.
You know what? I don't understand a word you said. Seriously, this is for most folks.
I'll be happy to explain. If you have a case in which you believe that an election was wrongly decided, as
I
happened
don't
in
have
the
much
9th
time.
Congressional District.
I don't have much time.
You
So-
go to court and you prove your case. That didn't happen in the 2020 election.
So do you believe that a lot of those legal challenges, I guess only one was upheld, that it was proper decision by the court to throw all those challenges out?
I don't have all those cases in front of me, and I
Well,
haven't
here's
reviewed all. I
what
haven't
I'm getting
reviewed
at.
all the cases.
Here's what I'm getting at. There's a subtext here. And the subtext is whether there's going to be ongoing challenges, and there's a certain person running for president right now who's already still talking about that as being rigged. And election integrity that you're talking about includes getting rid of what has been a significant protection in Shelby County with preclearance. Also, my understanding, maybe Mr. you can describe this, is that since Shelby, there have been numerous restrictive voting statutes passed in various states. Can you just comment on that?
Well, sure, and I think the record's very clear on that. We've heard testimony earlier today. There's something just very strange, whether it's political opportunity or some coordinated effort, that all of a sudden, around the nation, we see so many restrictive voting laws all of a sudden.
Well, by the way, my understanding from the Brennan Center study is that the incident rate of voter fraud is about 0.0003%. Does that conform to what you understand the data says?
It does. I described it earlier as infinitesimally small, and you've given some metrics to that.
All right, so a lot of these voter restriction laws sound valid, but they sound okay, neutral, which of course is what was the case with a lot of the Jim Crow provisions that prevented so many people from voting for so long. It appeared on its face to be neutral, like voter ID laws. But if that is the incidence of fraud, 0.0003, it seems to me that many of these laws that make it a little bit more onerous for people to vote are laws in search of a problem. Would you agree with that?
I would wholeheartedly agree.
I want to talk a little bit, too, about this is a slightly different topic, but re-enfranchisement laws. Vermont actually and Maine are two states that allow felons to vote. Many states have laws that allow a person who's completed his or her sentence to vote. I think that's important because I think voting is an action, a decision. But the process of voting is engagement, civic engagement, talking with your neighbors, talking with your friends about your point of view, about how you can build community through civic action. I'll ask you, Ms. Larkin, do you have any views on the importance of including the opportunity for people to vote who've completed their sentences?
Thank you for that question. We absolutely support the restoration of rights for people who have been convicted of felonies or other crimes. These laws, these felon disenfranchisement laws, have been rooted in Jim Crow and unfortunately have continuing impacts on the ability of communities of color in this country to be able to have their voices heard, particularly after they've completed their sentences.
Okay. Thank you very much. I yield back, Mr. Chairman.
Thank you, Senator. Senator Cornyn.
Would you raise your hand if you believe that our existing voting laws are rigged to the detriment of African Americans and persons of color? I don't see any hands. I agree with you. I don't know really where to start. I'm not sure what the John Lewis Voting Rights Act is supposed to try to solve. If you don't believe that the current system is rigged against African Americans or persons of color. What it does look like to me is an enormous power grab by the federal government to the detriment of the states like mine, like Texas. I think one of the ways that people get sucked into this argument is this idea that Shelby County versus Holder somehow decimated the Voting Rights Act. We know that's false. In fact, I voted to reauthorize the Voting Rights Act. I believe someone mentioned it was 98 to
to 0 in 2006. But what we did point out at the time was our Democratic colleagues chose to say that basically this country was still living in the 60s. In other words, the data that applied to the formula of coverage for the pre-clearance requirement was not updated to current events. Because I think, as has been pointed out, now we're seeing persons of color voting at levels equal to or higher than other parts of the voting population. We should be celebrating the success of the Voting Rights Act. It worked, and thank goodness it did. But in another sense, we've been fighting since the inception of this country for what the role of the federal government is. Is it a national government? Is it a federal government with states having their own sovereign rights? And here, the Supreme Court said there is no general right to review and veto state laws before they actually are enacted. That's what pre-clearance provided in Shelby County. And the Supreme Court said there is no right to that unless it's to remedy past discrimination. And what they pointed out is the Voting Rights Act did work. And that now, as I said, the level of voting by minorities was at or higher than that for the general population. I think we should celebrate the success of the Voting Rights Act. But I have to ask you, Mr. Spakowski, and forgive me if I butcher your name, you're probably used to it by now. I know you studied this area for many, many years, as Ms. Reardon has as well. Do you trust the Biden Department of Justice to make these decisions?
No, not at all. I mean, just to give you one example, when Arizona decided, one of the things that I've recommended for years is that all states should put in audit requirements. That's ubiquitous in the business world, and states ought to audit their elections after they're over, make sure that everything was done properly, the equipment all works, that they complied with the law. When Arizona decided to do an audit, the Justice Department suddenly said, oh, you can't do that. That's a violation of the Voting Rights Act. Well, that's ridiculous. Of course it's not a violation of the Voting Rights Act. But Senator, you were saying, what's the purpose of this bill? Can I give you one example of what I think the purpose is? It makes changes to Section 2 that would make it almost impossible for states to defend ordinary, regular practices of voting. And the example I would give you is that, Arizona was sued in a case went all the way to the Supreme Court, the Baranovich decision, in which, why were they sued? Well, because like the vast majority of states, they said, look, you have to vote in the precinct you're assigned to. And if you vote outside of that precinct, we're not going to count your ballot. That's the rule in most states. It's been that way for decades. And yet what the Section 2 change would make is to say, oh, if you are a state or sued under Section 2, you can't defend a law, you can't claim it's not discriminatory by showing that this is a traditional voting rule that's long established and that has been used in the majority of states. That will no longer be a defense.
Thank you.
Senator Butler.
Thank you, Mr. Chair. Thank you for holding such a timely hearing. And I thank all of the witnesses for joining today. I came to today's hearing truly with an open mind, believing that free and fair access to voting was in the best interest of both parties and all Americans. And I did find one thing that I agree with Mr. Von Spakovsky about. It is not 1965, sir. It is the year of our Lord 2024. And just because we are not being asked to count the number of jelly beans in a jar or bubbles on a bar of soap does not mean that states and local jurisdictions are not indeed continuing to discriminate. I held a hearing in Montgomery, Alabama, just last week, learning about the restrictive laws that were being considered in the Alabama state legislature, targeting, in my opinion, and the opinion of many legal scholars in the state, and those who were being asked to serve under those laws, targeting communities of color, Black Alabamians, people with disabilities. And I would like to start my question with you, Ms. Lincoln, about communities, people who live in the disability community. In Alabama's SB 1 that just passed the House last week, there are criminal penalties for being proposed with up to a decade in prison for those who would assist someone who is living in our community with disabilities with filling out and completing their absentee ballot. We heard the testimony of Laurel Hatton in Alabama, who suffers from lupus and is unable to drive. She would be subject to up to a decade in prison if she gave her neighbor $5 to take her to the poll to cast her ballot. Now, we know that there are many millions of Americans who live with disabilities just like Ms. Hatton. Can you talk to us about any cases that the ACLU find themselves in litigation specific to discrimination targeted towards people in the disability community?
Yes, absolutely, and thank you for that question. Unfortunately, voters with disabilities are far too long, have been overlooked, and there is unfortunately an enormous cross-section between voters of disabilities and voters of color, voters with low income and the like. And we've seen these attacks, a similar attack as you've mentioned in Alabama, in places like Mississippi and Georgia, and we are engaged in litigation in both. In Mississippi, have been so far successful in blocking a restriction on who can provide assistance to voters with disabilities in casting their ballot, which I think we should all be extraordinarily concerned about.
And I wonder what kind of political crusade it might be to advance a person living in a wheelchair to access the ballot. Thank you so much. Mr. Hewitt, we also learned about the story of Mayor Patrick Braxton, who was elected the first Black mayor of a small town of New Bern, Alabama. These are some, I think Mr. Braxton's case is an example of the updated but undeniably discriminatory practices in evolution of state and local jurisdictions. We heard about Mr. Braxton, who was literally locked out of City Hall after being duly elected the mayor of New Bern, but he was locked out by his formerly all-white city council and prevented from taking his seat. Can you, and has your organization seen instances of this kind of blatant voter suppression, updated and modernized voter suppression of election result rejection that is happening across the country?
We certainly have. I think the most marked example is not the January 6th insurrection, but what happened before then, when the Lawyers Committee and the NAACP sought to intervene in some 15 cases after the 2022 elections were over, where folks were trying to use the courts, state courts, to overturn elections. And sometimes they use extrajudicial means as well. And so we needed to have an answer in the courts of law because the court of public opinion is clear that the election results were over and that we needed a peaceful transfer of power. And so we're very worried about the same thing happening at the federal level, at the local level, and at the state level once again.
Thank you, Mr. Hewitt. Mr. Chair, I'm done with my questions and yield back the time.
I'd like to recognize Senator Blackburn for her questions. And I also want to just take note that I have a lot of power now because I'm effectively...
Yes, you do.
Yes, thank you. I'm effectively the acting chair.
Senator Booker, if you and I had all the power we needed, we would straighten out this NCAA NIL mess.
Amen. Hallelujah.
As well as a bunch of other things. Welcome to everyone. Thank you for being here for the hearing. One of the things I repeatedly say is we need to make it easier to vote and harder to cheat. That is what Tennesseans want to see. Easier to vote, harder for people to cheat. And Tennessee has really made some great progress when it comes to addressing how they run elections. And so many different organizations, secretaries of state, different ones have recognized Tennessee for having the most secure elections in our country. And Mr. Spikowski, I think your organization is one of those that has recognized Tennessee. And, you know, making it easier to vote, making certain those votes are secure is something that should not be controversial at all. Now, I think one of the things that has played a role in Tennessee is the fact that a photo ID is required. And I have to show a photo ID when I go to get on a plane, when I go to the pharmacy to get a prescription, when I go to a grandchild's school. If I'm checking in for an appointment somewhere, you always have to show a photo ID. And that is something, it's a basic security measure, but I know there are states like California, Illinois, New York, and they have not implemented that. So, Mr. Spikowski, I do want to come to you. Talk a little bit about how Tennessee is ranked #1 when you look at election integrity and safe elections, and then talk about the need for a photo ID.
Let me take the second one first.
Sure.
Look, I just don't know why we're even still arguing about ID requirements. Like I said, they've been in place in many states since the 2008 election. All the studies show that not only did registration turnout not go down in those states, it increased. Georgia, one of the first states to put it in, has had record turnout. And like I said, that one of the reasons is everybody's talking about, oh, people can't get an ID. Every state has put in a free ID for anyone who doesn't already have one, but Americans overwhelmingly have ID. So it's just not an issue. And the polling, look, Americans disagree a lot of stuff. But one thing they agree on, and this has stayed consistent over the past decade, is it doesn't matter whether you're black or white, Hispanic, Asian, or whether you're a Democrat or a Republican, overwhelmingly Americans say ID is a common sense requirement because they have to do it every day.
And if I can interject right here,
Yeah.
not only do Americans overwhelmingly support that, then Justice Stevens wrote in the Crawford case supporting
Right.
photo ID.
Yeah, he wrote the majority opinion upholding the constitutionality of it. By the way, that was over Indiana's voter ID law, and with the new law in place in 2008, Barack Obama won the state of Indiana, the first Democrat to win it, I think, since the 1960s. On integrity in general in Tennessee, in 2021, the Heritage Foundation, where I work, premiered a election integrity scorecard. We came up with almost 50 different criteria, best practices recommendations on how states should handle their elections. And it covers everything from making sure you have accurate voter registration lists to making sure you have full transparency so that observers of all the parties can watch what's going on. And then we rated each state according to their rules and regulations in place. And we continually update it. I think Tennessee now is at the top of our rankings because they've made a whole series of changes to improve the security of the election process.
Excellent. Thank you so much. Thank you, Mr. Chairman.
You're very welcome, and just because of the power of the chair, I'd like to first, before I go to the next senator, recognize the members of Delta Sigma Theta that are in the audience, a service organization. And I'd also just like to note, for the record, so we have this in writing, that I am in a position higher than Tom Cotton physically, at least, and I think that's very important to note. I would now like to go to the next esteemed senator, handsome and brilliant. I recognize Senator Cory Booker. I've really appreciated the conversation from the panel, and more than you know, as I travel around the globe and look at developing nations and developing democracies, I've studied the work of Larry Diamond, who works at the conservative Hoover Institute at Stanford. I think that we have this clutch our pearls kind of attitude that people in power don't try to affect rules that benefit their power. That's the reality. And the brilliance of our founders was try to design a government model where there would be checks and balances on that power. It states explicitly in the Constitution about our authority over federal election laws. And that's why I'm sort of stunned here about all this conversation that there are not attempts in around our country of people trying to rig the rules or to benefit them. And this isn't a partisan issue. I look at gerrymandering in America, and it is ridiculous. Both parties do it. They try to design maps that I think subvert the ideals of our democracy, which is that voters should choose their representatives, not their representatives choose their voters. I was very frustrated that in Congress before last, we tried to pass a bill that would have created far more drawing of electoral lines, but was blocked by House Republicans. It's not as partisan as people think, because when I was coming up in Newark, New Jersey, we had a very powerful political machine there. I believe they were doing things to subvert election fairness. And then Republican Chris Christie, who was the U.S. attorney at the time, stepped in to try to ensure fairness. So let's be clear, it happens. We know that there are people trying to game the system in ways that benefit their dominance in the political system. It is the natural inclinations that our founders talked about. The Federalist Papers have extraordinary expositions on to how power can corrupt, and we are trying to set fair laws to stop it. Gerrymandering is an example. Campaign finance rules, to me, it's outrageous to me. Even the Supreme Court said the fact that dark money could be drowning our politics like it is today. They called for a disclosure of that. We've tried time and time again, Democrats, to pass the Disclose Act. No American really wants dark money billionaires potentially having foreign influence to try to influence our elections. And so I'm not ascribing these issues towards racism. I'm describing them towards people that are trying to game the system. When the North Carolina, we already heard the quotes about designing something with surgical-like precision to racially affect the election. If you look at the actual emails that they pointed to of the legislators themselves, they were trying to glean electoral advantage, and their thinking was that black people were going to vote for Democrats, so let's design a system to stop black people from voting. And so that's the frustration. We're acting here like these things don't go on, like there aren't people always trying to game it that are having real effects. One of the most frustrating effects for me is just voting wait times. I've seen people designing it so college campuses, it's harder to vote, there's less voting machines, and there are lines I've seen that are outrageous trying to discourage kids from waiting online. Well, the same thing actually happens in African-American communities. In Georgia, the data, and I'll enter the article for the record without objection, no objection being heard, that demonstrate that the significantly longer wait that African-American neighborhoods have than white neighborhoods. And so I'm a little frustrated here that we who are guardians of our democracy, not trying to get political advantage, aren't trying to find ways to make the system more balanced and fair, because the system will be abused if we don't. I heard one of our witnesses talking about there being the voter turnout for African Americans. Hey, I've been psyched about it, but when you look at the growing racial disparities in voter turnout, the Brennan Center has a great point to this, these gaps are growing because of a lot of this gamesmanship. And so in the remaining minute that I have, I just want to ask about this issue of the racial gap in voter turnouts. And Ms. Camarillo, can you talk about the barriers that voters of color are facing that could drive the kind of growing disparities here, and what we can do in a way to make the field more fair?
Well, it depends, thank you. It depends on the states, but one of the things that they're concerned about is, A, their vote's not going to be counted, that the laws also are not allowing them to participate. If they're low income and they live in neighborhoods where the voting polls have been either moved or they're too far away, it's very hard. If they need to get their voter ID, sometimes they don't have any resources or places are closed. And frankly, in Texas, the Attorney General at the time was Abbott, spent $1 million to demonstrate that there was fraud, and he found nothing. So for us at Southwest Voter, I have to say that yes, there are more Latinos and more Blacks and Asian communities and voters that are voting, but we're not taking into account the organization and the organizing that is happening by the communities themselves, in spite of the violations and the efforts to block them from voting. In the redistricting case in Texas, we've basically have lost 5 congressional seats that that should have been Latino majority seats. 2 that were weakened, the 15th and the 23rd, and 3 that we should have gained. And so we see this over and over. And so in that case, I was asked when I was deposed in our Senate Bill 1 litigation, isn't it true that you're going to be working in South Texas anyways, which is District 15? And I said, that's not the point. If voters think that their vote is not valued when it's cast, why should they turn out to vote?
Thank you. I just want to, I'm over my time. I want to recognize Senator Tom Tillis next, and there's going to be a peaceful transfer of power now, something very important to the traditions of our government. I hand over chairmanship to the far more senior senator, more experienced, wiser, more hair, Senator Whitehouse.
I'm flattered.
I think I got recognized. I am.
Yes, sir, you
Actually,
did.
I thought I was just walking in before I got seated, and you said you were going to introduce a dashing, handsome person. I said, man, I'm not even at my seat yet. So thank you all for being here. I've got a little bit of history here because my signature as Speaker of the House is on a voter ID bill from many years ago. I remember the negotiation vividly because I said that on the one hand, I think it's reasonable to require a voter an identification. But then I was subject to loud criticism from the right for also suggesting that HAVA documents and other documents could be used if, in fact, you didn't have a driver's license. I was criticized from the left for saying, why do you think you need an ID? Some people just don't have an ID. I said, well, how about if we provide an ID for free? Because it seems to me having a valid government-issued ID is liberating. It's how I get on an airplane every week. It's how I purchase prescriptions. It's how I fully participate in society. And so I don't really understand it if the laws are one that tries to do everything that you can to provide person with good access to an identification. I had to cast my vote early. I like voting early. I didn't have any problem with remembering to bring my ID with me. But I know if I hadn't, then I could have had other forms of ID that could have possibly given me access to the poll. So I really just don't understand the downside for overcoming the cost, the accessibility, the number of other things. Not to mention, I don't understand, if you really don't want a government ID, if you don't want a government-issued ID, if you don't want to have access and fully participate in all that requires an ID, up to and including getting in a hotel room, then why not vote by absentee ballot? If it's mailed to your home, you can cast a ballot. You don't have to provide an ID. Did that, didn't need an ID. Last time, I voted early. This time, I voted early in person. So I don't know what we're missing here and why we're making this such a polarizing discussion. I didn't have anyone tell me with any statistical validity that the law that I was passing and the HAVA docket provisions and everything else were really being that difficult. And incidentally, I did hear, I'm going to call you Hans because I don't want to butcher your last name. I did hear Hans's opening statement, and I'm a data-driven person. So look, if there are injustices, I don't want that. I want to fix it. And by the way, I know Senator Booker has left. An interesting thing happens when elections occur. When I was in the minority for 4 years, I signed on to and tried to sponsor independent redistricting. I tried to go to Speaker Hackney, who was a Democrat, and the Democrat leader in the Senate say, we ought to try and get this done. They were against it. Now, fast forward 3 years later, I'm Speaker of the House. You know what I did? I endorsed independent redistricting. You know what Hackney did? He finally supported. But guess what? You know what the Republicans did? They didn't. So what people need to do is take the opportunity when they're in the leadership to look their party in the eye and say, we need to end this cycle. There is a way to do it fairly, and there is a way to do it with political considerations on the end. But in the same way that voter ID laws have been politicized, and I'm not trying, what I want to do is maximize access to the ballot. If you can tell me how I can tweak a voter ID law and still keep what I think is a rational expectation at the time somebody's going to vote, same expectations required at the time I'm going to go through security at an airport or to check in a hotel or get my prescriptions, count me in. I'll fix it. But I think that some of these discussions are politically motivated and unproductive. Hans, I know technology well. I can still download the voter files and have fairly recently. In North Carolina, put it in an Excel spreadsheet, an Access database, go through and find people that look roughly my age or the age of some other ethnicity based on a name association. And I can find a lot of people who haven't voted for years. Now, if I'm a smart person and I know that there are certain districts that are going to win by a couple of hundred votes, there are congressional races that are won by a couple of hundred votes, I can guarantee you I can find a couple of hundred people spread out over several precincts who have not voted. And if I chose to, going in with my name or going in with their name, vote, and without a no voter ID requirement, I could literally, I wouldn't, just so my comm staff is watching, I wouldn't do this, but a bad actor could literally reverse the outcome of an election by abusing the fact that you don't have to present an ID. Do you agree or disagree with that?
Well, I agree, and in fact, I wrote a case study about a state grand jury report that was published in New York, conducted by Elizabeth Holtzman, former Democratic Congresswoman, who then went back and became a DA, and she released a report, an entire grand jury investigation. That's exactly the way she found that for many years, elections have been stolen.
I'm cognizant of the time and the fact the vote's going on. Folks, people are interfering in our elections. Foreign actors are smart enough to take what I can do on an Excel spreadsheet and a laptop and do it at scale. Let's try and figure out how we get past the political divide here and recognize that this is a legitimate discussion to have about integrity of elections. So not having a political hearing, have one with results. And by the way, count me in if everybody, when they're in a position to make a change and they have the gavels, let's also work on redistricting. Thank you.
Senator Hirono.
Thank you, Mr. Chairman. I thank everyone for testifying on this really important issue because practically nothing, aside from a woman's right to control her own body, could be as important as voting. And we know that there are all kinds of efforts. After Shelby County, I think some 13 states immediately enacted what I would deem to be voter suppression laws. And these take all kinds of forms, and in fact, it's to make voting harder. Anything that makes voting harder, such as changing the times that people can vote, or changing where people can vote, or restricting the kind of identification that can be used to go and vote. These are all, I think, efforts. These are all efforts to suppress people's votes. So I have a couple of questions relating to what will be happening probably in this election cycle. I did want to ask one of our testifiers a question relating to robocalls. So this is for Mr. Hewitt. Last year, your organization brought to light a racially targeted voter suppression operation in the form of a robocall scheme. Probably these kinds of schemes are going to be utilized in this upcoming election season. I think they're pretty easy to do and maybe not that hard to stop. Can you, Mr. Hewitt, tell us a little bit more about the case that you brought and what kind of robocall was it and who did it target?
Thank you, Senator Hirono. During the 2020 election cycle, we received through the Election Protection Coalition hotline, 866 Our Vote, calls from voters indicating that they were receiving robocalls in which there was apparently a voice actor, we later learned, who was hired to say something to the effect of, if you vote by mail, the information will be used against you to collect outstanding debt, to execute outstanding police warrants, and to force mandatory vaccinations. The kicker line was, don't give your information to the man. We traced this to a gentleman named Jacob Wool and his compatriots, who we learned on the cheap were able to send 85,000 such robocalls, and they tried to target black voters. We filed suit under Section 11B of the Voting Rights Act. These individuals were later prosecuted successfully and convicted, and we won on summary judgment, and we're going after damages from these folks as well. We represented the National Coalition on Black Civic Participation, which had to divert resources to address these issues and re-inform these 85,000 voters about what the law really provided. That was done on the cheap. That was in the 2020 cycle. Today, the same robocall could be done in an AI-assisted way, and it could clone the voices of people like Barack Obama or Morgan Freeman or Oprah Winfrey or anyone who's of notoriety, and people can be fooled. And so we need protection from this. We won our case because that was found to be voter intimidation, but not all mis and disinfo that's designed to chill the vote is going to rise to that level. So we need more protections.
Aren't there bills that have already been introduced that will prevent these kinds of robocalls from occurring?
There certainly are some bills introduced, which we can certainly talk about and figure how we can all rally around and support. There's also action by the executive branch, the FCC, to ban use of robocalls, at least in federal elections, AI-assisted robocalls, that is. And so when we think about how we make it easier to vote, and how do we actually make it harder to stop people from voting, we have to think comprehensively in this way.
Considering that the Voting Rights Act used to be reauthorized in a bipartisan way for decades, and suddenly the Supreme Court decided to become very activist, and the Shelby County pretty much decimated the Voting Rights Act, and then they went on in another case to make it even harder to go after Section 2 violations. So I do have a bill that some of you, your organizations, support, the Time Off to Vote Act. This is a bill that would require employers to provide 2 hours of paid time to vote. So for Mr. Hewitt and Ms. Lacken, your organization support this bill. Can you explain a little bit why you think that this is important, even in places where there is voting by mail?
Yes, absolutely. We definitely support this bill. There are far too many people in this country who are unable to take time off of work to be able to access mail balloting, which isn't available in the same way across the country. And so being able to, first of all, recognize the importance of voting, and recognize the importance of employers to provide that opportunity for voters is extraordinarily important and increases access in a way that we absolutely support.
Mr. Hewitt, would you like to add?
Thank you, Senator. We support that bill as well. And as I talk to people in corporate America, we ask them to do the same, whether they're legally required to or not, and also to lift up what they're doing because their reputational capital matters. We want to mainstream not just the active voting, but also the importance of opening up pathways to be able to exercise that right.
This bill already has dozens of sponsors. You know, can one of you submit the list of all the kinds of voter suppression laws that have been enacted across our country? My time is up, but maybe one of you can supply that to us, because voter IDs is just one of many, many ways dozens of ways that voter suppression is taking place in our country.
Thanks, Senator Rono.
Thank you.
Senator Whitehouse.
Thanks very much, Chairman, and thanks to all of the witnesses for being here. I'd like to take my time as we close out this hearing to interrelate the problem that we're talking about today with the related problem of right-wing capture of the United States Supreme Court, an enterprise which the Center for Media and Democracy says has cost $570 million. Pretty darn big number to spend if you don't expect results. So sure enough, it seems that they got results for their expenditure, and I contend that one of those results was the Shelby County decision. And I'd like to focus a little bit on the fact-finding piece of that decision. I think we all know, anybody who's a lawyer in the room knows that as a general proposition in the American system of justice, the facts get found at the district court level. That's where the adversarial process can be brought to bear on potentially false facts. That's where the parties who are charged in our system to bring in facts and present to the judge have the opportunity to do that. That's where appellate scrutiny of errant fact-finding can take place. And the result of all of that is quite a robust and honest fact-finding process in the United States system of justice. Those safeguards fall completely apart when at the very end of the day, after the arguments, after the briefs, at the very highest court level in the Supreme Court, the justices in the majority invent new facts. Just as a procedural matter, they're not supposed to do that. And it's particularly frustrating and concerning when the facts they find are false ones. In Shelby County, the majority opinion determined that things had changed dramatically on racial gerrymandering, voter suppression, and other issues in the pre-clearance states, the ones that were under the rule that they had to submit new rules for clearance to a court or to the Department of Justice before they could proceed, and made the decision that this part of the Voting Rights Act was no longer justified by current needs. And that question of how much things had changed and what the current needs were had no foundation in the court or the legislative record. There were lower court determinations that pointed out significant voter suppression efforts in Shelby County itself and in Alabama more generally. What the court did was to take that statute and look at it as a facial challenge to the statute, which got it by having to reckon with the judicial record that had been established of persistent voter suppression efforts. So they just shot by the record that existed. That was supplemented by a congressional record from the reauthorization of the Voting Rights Act, which was very robust and represented hours of hearings, enormous amounts of documentary work, testimony from experts and advocates and people in the pre-clearance states. And the congressional record was very clear that reauthorization was justified, that some of the techniques of voter suppression had changed, but even though some of the techniques had changed, new techniques had emerged, and therefore the pre-clearance process should be renewed, and that was accomplished on a bipartisan basis, with a massive bipartisan vote in both houses. And what the court did was simply pay no attention to the congressional record, to basically write it off. Well, folks, we're an independent branch of the government. We've got every bit the right of the Supreme Court to decide what the facts are in a matter. We're actually the place where that decision better belongs, because if we get it wrong, voters can have a say about that. Whereas if the Supreme Court gets it wrong, we're stuck with zombie decisions based on false facts that just persist and persist and persist unless and until the Supreme Court is willing to clean up its own errors.
but it's hardly likely that they will persist in cleaning up their own errors when they went ahead and made the errors in the first place. So there's a test of whether or not this was accurate, and the test was real life. And in real life, as soon as the preclearance was lifted, there came an avalanche from preclearance state after preclearance state, over 100 pieces of legislation, sometimes targeting minority voters with what one court called surgical precision to affect the election outcomes to the benefit of Republicans in those states. That is the background that bothers me. My time is expired on this, but I did want to make that point, and I thank the chairman for holding the hearing.
Thanks, Senator Whitehouse and Senator Ossoff.
Thank you, Mr. Chairman. Thank you to our witnesses. You know, Mr. Hewitt, it is extraordinary the lengths to which Republican state legislators in Georgia have gone to try to make it harder for some folks to vote. They passed legislation that makes it harder to request an absentee ballot, that shrinks the period of runoff elections to drive up lines at polling places during early voting in runoff elections, that allows anybody to file limitless, frivolous challenges to the eligibility to vote of their own neighbors. So I was 6 activists on the basis of this in 2022 challenged the registrations of 89,000 Georgia voters. All of this intended to make it harder for some folks to vote and therefore to gain an edge in elections. It's about partisan political power. I am introducing today legislation called the Right to Vote Act. And this bill would empower voters to challenge in court any action taken by a state or local government that makes it harder to vote, and force that state or that locality to demonstrate that the restrictions serve some governmental purpose and are the least restrictive means of doing so. Mr. Hewitt, why is it essential that voters be able to challenge voter suppression policies in court?
It's essential because otherwise they have rights with no remedy. And that's exactly what some people are after. You know, we had to fight tooth and nail, Senator Ossoff, just to get a preliminary injunction on a couple of those provisions that you mentioned, on the line warming provision outside of 150 feet of a polling place, and also the provision that trick voters where you have to have your date of birth on an absentee ballot, and many people just write the date that they're submitting the ballot by instinct. And so it was viewed as immaterial by the court. But there's so many other provisions that have not been addressed. But your legislation is so critical, we believe, we're glad to see you introduce it, because the notion of a positive affirmative right is what we should have in this country. We have the constitutional provision that prohibits discrimination in voting, and statutory provisions which we seek to strengthen, but a positive affirmative right is what this country should be all about. And so we applaud your introduction and look forward to supporting your legislation.
Well, thank you for supporting the bill. And the basic idea is that if states or local governments are going to make it harder for eligible voters to vote, then they should have to be able to prove in court why it's necessary and that it's the least restrictive means of achieving whatever their objective is. And I just want to reflect in closing here on the context for what's happened in Georgia. Well, let me just say, Mr. because we had just concluded a presidential election and 2 of the most consequential Senate runoffs in U.S. history. Democrats had prevailed in those races. The former president, as you'll recall, had put immense pressure on the governor of Georgia, the Secretary of State of Georgia, to commit what may have been felony election crimes and overturn the results. You'll recall the former president saying, just find me 12 or 13,000 votes to try to overturn the outcome of the election. No evidence whatsoever supporting the former president's conspiracy theory has been presented. There was just a lengthy piece written in the AJC by a gentleman named Ken Block, who was hired by the Trump campaign to try to find this alleged fraud? He found none. Nevertheless, the state legislature advanced this legislation, passed a law to drive up the time it takes to wait in line to vote during runoffs, make it so no one can bring you so much as a drink of water while you're standing in line, allow these unlimited challenges. I mean, the fact that people are spending their time filing frivolous challenges to their fellow Americans' eligibility to vote should outrage us. And we need to establish, as a matter of federal law, that voters have a say in court where their rights are infringed without some specific reason for the restriction and a demonstration that it's the least restrictive means of doing so. I thank you all for your testimony, your expertise, and your advocacy.
Thank you, Senator Ossoff. There's one more senator on the way, so I'll just wait, kind of pause for a moment here. But let me say a word to my colleague from Georgia. I think you've really put your finger on the major issue here. It is time for us to establish the right to vote in this country. And those who would take away that right have to pay a price and answer to the judgment of not only of history, but of their peers at this time in history. I think you're moving in the right direction. I want to support your effort in that regard. I think it's also important to note that the excuse, and I call it an excuse, given for a lot of this misconduct is voter integrity. And when the facts come through and it's 0.003, maybe I missed a zero there, 0.003 of the incidents of fraud and abuse, you have to ask yourself, what are you sacrificing in the process to have this kind of scrutiny and this kind of obstacle in the path of the voter? They're trying to exercise their right. It's a rare occurrence. We want to eradicate it if we can, but to do it at the expense of people's right to vote is just fundamentally wrong as far as I'm concerned. So thank you for raising that issue. I appreciate it very much. We're going to wait here for a moment.
I would note, Mr. Chairman, since we're waiting for a colleague to arrive, something else that happened during that infamous period where the former president was hell-bent on overturning the result in Georgia based upon baseless conspiracy theories. The U.S. attorney for the Northern District of Georgia resigned because he was coming under pressure from the White House or the Trump campaign to participate in this effort to overturn the election result. And let me just remind everyone again as we wait for our colleague to arrive, zero evidence. Zero evidence. The very man hired by the Trump campaign to try to find this alleged fraud, to substantiate this conspiracy theory, just wrote a long article about how we found nothing. Nothing. Thank you, Mr. Chairman.
Senator Cruz?
Thank you, Mr. Chairman. Once again, we're at a hearing for an incredibly partisan piece of legislation. Just after last week, where all of us witnessed the most partisan, angry, bitter, divisive State of the Union speech in the history of our country. So I guess we shouldn't be surprised that Democrats once again seek to divide us. Contrary to the prevailing Democrat narrative happily repeated by the corporate media, that Republican-sponsored legislation would herald a return to Jim Crow. I would note, by the way, Jim Crow laws were drafted by Democrats to ensure the voters could only elect Democrats. That's what Jim Crow was designed to do. The reality is a majority of Americans support legislation that protects election integrity, that protects the right to vote. And yet, today, Democrats are not interested in election integrity. They are interested in power. Power by any means necessary. And so the Democrats' focus is on controlling elections and controlling the outcome. There's an irony. Today, Democrats love to beat their chest and say they are defending democracy. And yet, all across the country, we see Democrat courts and Democrat officials who have been trying to throw Donald Trump off the ballot. Because nothing protects democracy like preventing the voters from voting for your opponent. When the Colorado Supreme Court decision came down stripping the voters of Colorado of the right to vote for President Trump, I said that day the decision would be reversed by the U.S. Supreme Court, and I said it would likely be reversed unanimously. It was reversed unanimously. I invite anyone in this room to point to even one prominent Democrat who criticized that baldly anti-democratic power grab. And not only Colorado, but Maine and Illinois stood up and said, we hate democracy and we will not let the voters vote for our opponent. In the Supreme Court, I led a brief on behalf of 179 members of Congress arguing that Colorado's actions striking President Trump's name from the ballot were unconstitutional and that they endangered democracy. You know who didn't join that brief? Even a single Democrat. Because when it comes to democracy, today's Washington Democrats have zero interest in the voters actually deciding. What they're interested in is anything that maintains Democrat power. And what they oppose is anything that creates even a tiny window that the voters might choose to vote for somebody else. Today, Democrats are pushing a bill that has many terrible provisions. But let's cut to the heart of it. This bill would institute two types of pre-clearance. Pre-clearance for everyone Democrats don't like, and pre-clearance for everything they don't like. This is about power. This is not about election integrity. This is the opposite of election integrity. Here's how it would work. Every state and local government across the country would have to submit certain voter changes. Things like voter ID requirements or prohibitions on ballot harvesting to radical partisan activists at the Biden Department of Justice like Kristen Clark, who has not been shy about her hatred of voter integrity laws. And by the way, spoiler alert, the Biden Justice Department would refuse to pre-clear all of them. Anything enhancing election integrity, the Biden Department of Justice is opposed to. Similarly, state and local governments that the Democrats don't like would have to submit any voting changes to the Biden Department of Justice, which sadly has been the most partisan and political Department of Justice in our nation's history. Mr. von Spakovsky, welcome back to the committee. Although Democrats are holding this hearing under the guise of caring about voting rights, it's ironic because they're the party that just attempted to disenfranchise millions of Americans. I want to talk to you about that irony. Mr. von Spakovsky, how many Colorado voters would have been disenfranchised if the Democrat Supreme Court had affirmed, if the U.S. Supreme Court had affirmed the Democrat Colorado Supreme Court?
4.5 million registered voters.
Does disenfranchising 4.5 million voters, is that enhancing democracy?
No.
Are you aware of any major Democrats who spoke out in support of democracy and against disenfranchising millions of people in Colorado?
I am not.
Are you aware of any major Democrats who spoke out against disenfranchising voters in the state of Maine?
I am not, and that would have been 1 million registered voters.
Are you aware of any major Democrats who spoke out against disenfranchising voters in the state of Illinois, which is the home state of the chairman of this committee?
I am not.
And that was one lone district judge who said, nope, the people of Illinois don't get to vote for the Republican nominee for president. Mr. Van Spakovsky, you wrote a November 2023 report with two important findings utilizing 2016 and 2020 Census Bureau data. What were your conclusions regarding the 9 formerly covered states under Section 5?
That they had registration rates and turnout rates close to the national registration turnout rate or above it. And in fact...
And how did they compare to New York and California?
Yeah, well, they all did better than New York and California. including the turnout of registration turnout, not just of all voters, but registration turnout of black voters.
Thank you.
The 14th Amendment, Section 3, makes reference to a set of facts which clearly applied at the time in the 19th century, and most people assume would never, ever occur again in history. And that the existence of Section 3 civil or military and sent to a safe place until the thing of the United States could be secured. It was clearly down to stop disputed the. We have a criminal justice system in this country. We have civil litigation, and former presidents are not immune from being accountable by either one. That quote comes from Senate Minority Leader Mitch McConnell, who said that about the insurrection that occurred on January 6th. What the Supreme Court was asked to do was decide in the context of 2024, where are we in terms of that language, the rather clear language in the 14th Amendment, Article 3. They concluded the court rejected plaintiff's claims and found that, quote, because the Constitution makes Congress rather than the states responsible for enforcing Section 3 of the 14th Amendment against federal officials. Former President Trump from appearing on the ballot for 2024 election. They didn't say that the president was not engaged in an insurrection, but they said that isn't to be decided by individual states. It's to be decided by Congress. I don't think there was any great conspiracy here. There was a set of facts no one anticipated when this was originally written back in the 19th century. So that is a fact, and what I've read is directly from the Supreme Court decision.
Mr. Chairman, if I could ask a question to the chairman. Is the chairman saying that you disagree with the unanimous decision of the Supreme Court, and do you believe the voters should be prevented from voting for President Trump if they so desire?
No, I didn't say that.
That's why I'm asking.
I stand by the decision of the court.
Okay, good.
I appreciate all the witnesses appearing before the committee today. John Lewis, who was the inspiration for this hearing, famously described the right to vote as, quote, precious, almost sacred. I believe we have a sacred duty as members of Congress to protect this right. Throughout his life, John Lewis fought for legislation to combat voter suppression, and it is a great tragedy he passed away before Congress acted to restore the Voting Rights Act. Our country owes an outstanding debt to John Lewis and countless others who tirelessly fought to ensure equitable access to the ballot. I hope this Congress will honor their legacy by finally enacting this act into law. This hearing will remain open for a week, and questions may be submitted to the members of the panel who are kind enough to be here today. With that, the hearing stands adjourned.